Donald Trump's misogynist streak has collided with his attack on diversity, equity, and inclusion. And he's trying to undermine the Violence Against Women's Act, which is also known as VAWA, V-A-W-A, which was imposed by Congress in 1994 to address sex assault and other domestic violence against women. And Donald Trump has now, through his Office of Civil Rights and Violence Against Women, which was required to be established by Congress, is now trying to put them through a certain litmus test to undermine their First Amendment rights, to make them stop helping women, some of which may be undocumented, others may not be, but they're in this country and they deserve to be protected. How many times do we have to have a hot take where I say the obvious? Donald Trump hates women and certainly is doing everything he can to undermine all the things that Congress has put in place for the last 30 or 40 years to protect them. I'm Michael Popok. You're here on Legal AF. We talk about these hard issues without blowing smoke or sunshine, with a new lawsuit that's just been filed by Democracy Forward and about 17 different states and state coalitions. And it's been filed in Rhode Island federal court. Let's break it down right here on Legal AF. Take a moment. Let us know you like this kind of reporting. You need the unvarnished opinion sometimes, even if it's difficult to listen to, in order to make sense of it all. We try to demystify the intersection of law and politics right here. Let's get down to it. The lawsuit was just filed actually today in federal court, 80-page lawsuit. It sues for various violations of the United States Constitution and the Administrative Procedures Act. On the Administrative Procedures Act, it's saying that Donald Trump can't pull the rug out from under all of these state coalitions. They are all devoted to coalitions. Literally, they're known as coalitions against domestic and or sexual violence in every state. And every state has one since 1994 under VAWA. Now, the Administrative Procedures Act violation is obvious. Donald Trump is trying to impose his no diversity, equity, and inclusion by making them certify that they're not helping any immigrants who are undocumented. Well, they can't do that. That actually is against the policies of Congress that set up the law, who said it doesn't matter who comes to your doorstep. You need to reach out and help them. In fact, the funding mechanism for all of these coalition entities that exist in all 50 states is to incentivize the states to focus on violence against women. But if you had to pick a president that wouldn't care about violence against women and would try to victimize the victims once again, it would be Donald Trump. He is the misogynist in chief. He is the felon in chief. And now he's gone, of course, too far. Thank God there's a lawsuit that's been filed by a coalition of 18 different state organizations. So Administrative Procedures Act violated because they changed the law without going through Congress, without following the procedures to change the law. It's also a violation of the separation of powers under the Constitution because it is Congress that creates law, not the president. That's not what executive orders are supposed to do. Create new law or undermine existing law. That's for Congress. It's also a violation, as alleged in the complaint, of the spending clause, because it's Congress that funds these things. It's Trump that's supposed to execute on the laws already established. And by making them certify, they're putting them on the horns of a dilemma of violating the Federal Claims Act and being prosecuted for it, or serving the needs of the victims, the female victims, that Congress set up in 1994 a system and a structure to protect. And so after you get through the First Amendment violations, freedom of speech, point of view speech by these organizations, which are being attacked by Donald Trump, spending clause, separation of powers clause, Administrative Procedures Act, and you've got the injunction that they're seeking to stop this very thing. Because right now, these organizations are not applying for the grants because they don't feel that they're able to properly certify to Donald Trump the things he wants them to certify. And they're not going to be caught lying on a federal form and guilty of perjury. So they're on the horns of a dilemma. Here's what the complaint actually says. This is on page, the first few pages that outline how we got here. 31 years ago, Congress enacted the Violence Against Women's Act, the VAWA, to create a unified national response to violence against women. As Senator Barbara Boxer explained in introducing the bill, speaking of the thousands of women murdered by their current or former partners, we know that the criminal justice system is guilty because it routinely turns its back on this form of brutality and leaves too many women out in the cold. Over the last 3 decades, VAWA has had significant successes making people and communities safer, but the crisis that it sought to address remains urgent. As the Office on Violence Against Women observed just last month, over half of the women murdered in the United States are killed by a current or former intimate partner. That's from the office under Donald Trump. Talk about using his own receipts against them. Why didn't he should go check the OVW resource guide for addressing the intersection of domestic violence and firearms? Because it's up there right now. Congress has recognized in paragraph 2 that providing support to organizations and entities working on the ground with victims is critical to accomplishing VAWA's goals. It then goes on to say on paragraph 5 on page 2, plaintiffs and the victims they serve are now in grave jeopardy. As has been happening at agencies across the federal government, OVW has begun demanding, this is the Office of Violence Against Women under Trump, demanding that those that want grants, funding, certify compliance with a host of conditions that reflect the administration's broader policy agenda. These new certification requirements are untethered to any condition that Congress thought necessary or appropriate. Many of them are too broadly worded to be deciphered. They talk about gender ideology and trying to forbid grantees from pursuing that. They want to make sure that the grantees don't prioritize illegal aliens or promote and facilitate immigration violations, despite Congress's directives for certain programs to emphasize assistance to immigrants, and despite Congress's direction that the programs do not discriminate on the basis of alienage status. That's exactly what Donald Trump is doing. So they continue. On paragraph 7, plaintiffs and their members, which are all of these coalitions, 17 came forward now, are thus left in an impossible position. If they refrain from applying for grants, they'll lose out in funding. That's critical to provide the services they've long promised and offered that victims and survivors rely on for safety and protection. Yet if they make the required certification, they will be immediately expose their organization to substantial legal and financial risk, on top of agreeing to statements antithetical to their core values. Plaintiffs and their members could face harassing False Claims Act lawsuits, and they could face punitive remedies. And this is what they're asking the court to fix. Now, it's filed in Rhode Island for good reason. You know, as I've only half joked, it's the original colonies, now states, that are leading the way in this revolution to stop Donald Trump's abuse of power. That's why you hear lawsuits filed in Massachusetts, in Rhode Island, in New York, you know, all the way down to Maryland, and of course, the District of Columbia. Those are the key battlegrounds for trying to rein in an out of control, lawless, abusive, misogynist president in Donald Trump. Now, what they're seeking from the court includes temporary restraining orders and injunctions. So we'll have to follow this case very closely. The requested relief is to have a declaration or all of these requirements by Donald Trump against women and to victimize the victims need to be enjoined and to be declared invalid and unconstitutional. To preliminary and permanently enjoin the defendants acting in concert from screwing around with their funding. Now, the interesting thing is the main suit is asking for a preliminary injunction, but they're also seeking temporary restraining order, meaning an earlier determination by the court in Rhode Island about whether they're going to win or not, to try to block it now so they can get the funding without having to certify all of these illegal, unconstitutional things. So that's why we need to follow it closely. I'll let you know soon who the judge is assigned to the case by random selection. What that means likely for the pace of the case. The first orders coming out of the court to set this case up for temporary restraining order. Then what happens? The other reason things are filed in Massachusetts and Rhode Island is because the First Circuit Court of Appeals is moderate to liberal. And that's the next stop on the appellate train before you get to the United States Supreme Court. We will follow it closely. You're here already on Legal AF. This is the type of information I believe you need to know about as we cultivate and curate at the intersection of law and politics. If you like it, the no holds barred approach, giving you the truth so we can speak truth to each other before we speak truth to power, it's here on Legal AF. Take a moment, hit the free subscribe button, and continue to follow all that we do. So until my next report, I'm Michael Popok.
I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touches Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.